This is Litigating before the Maryland Board of Contract Appeals, presented by the Maryland State Bar Association in collaboration with the Bar Association of Montgomery County. Thank you so much for joining us today. My name is Javana Porkarim, and I'm an Assistant Attorney General for the state of Maryland, and I also co-chair the Administrative Law Section of the Bar Association of Montgomery County, along with my co-chair, Judge Henderson of the Office of Administrative Hearings. This conversation is being recorded, so by remaining in this training, you're consenting to being recorded. Please mute yourself when you're not speaking, and please feel free to type your questions in the chat or save them for the end when you can unmute and ask your questions. We have a wonderful set of speakers lined up for you today. I have the privilege of introducing Valerie Green, who is a Deputy Counsel at the Office of the Attorney General, and she is also the chair of the Administrative Law Section of the Maryland State Bar Association. Valerie, the floor is yours.
All right. Thank you, Javana. Thank
You're
you so
welcome.
much for putting this on as well. Today, everyone, first of all, welcome. We are excited that we have today's group of panelists joining us to discuss litigating before the Maryland State Board of Contract Appeals. So I'd like to take a moment to introduce each of our panelists to you. Sonia Cho was appointed by Governor Westmore as the chair of the Maryland State Board of Contract Appeals in January of 2024. She has served as a member of the Maryland State Board of Contract Appeals since 2022. She previously served in the Maryland Office of the Attorney General, where she was Assistant Attorney General for the Contract Litigation Division. She also has very broad experience in commercial litigation and practice law at DLA Piper and Gorman and Williams. Sonia earned her bachelor's degree from Binghamton University and her JD from the University of Maryland Francis King Carey School of Law. Our next panelist is Larry Kreis. Lawrence Kreis has been a member of the Maryland State Board of Contract Appeals since 2019. Larry graduated from University of Maryland Francis King Carey School of Law and clerked for Judge Waldron of the Circuit Court for Harford County. He then worked for 14 years at Stark and Keenan in Bel Air. Larry then moved to the Contract Litigation Unit of the OAG for 8 years, serving the last several as Deputy Counsel. From there, Larry served as a Circuit Court judge in Harford County before joining the Maryland State Board of Contract Appeals in 2019. Our next panelist is Phil Andrews. Phil is a business litigator and procurement lawyer. He practices in federal and state trial and appellate courts, as well as before administrative agencies, including for the last 30 plus years, the Maryland State Board of Contract Appeals. Phil has extensive experience in Maryland procurement matters, advising and counseling clients throughout the entire RFP, proposal evaluation, and contract award process. His work includes handling bid protests on behalf of protesters and on behalf of interested parties, contract claims, and other administrative disputes and litigation. His procurement clients span a wide variety of industries, including information technology, healthcare, transportation, cannabis, construction, and gaming. Phil also has substantial experience representing clients in litigation arising from public-private partnership projects in Maryland. Next on our panel is Melody Mabanta. Melody has been a litigator for over 25 years. In private practice, she litigated complex construction and catastrophic injury cases in Maryland's state and federal courts and in DC's superior and federal courts. Since 2011, Melody has served as an Assistant Attorney General for Maryland in the Contract Litigation Unit. Prior to her promotion to Chief of the Contract Litigation Unit in 2024, she held the position of Deputy Chief of the unit from 2017 to 2024. The Contract Litigation Unit litigates contract disputes and procurement protests before the Maryland State Board of Contract Appeals and the state circuit and appellate courts. Melody also serves as a faculty member for the National Association of Attorneys General, where she focuses on general trial advocacy. Melody graduated from Towson University with a Bachelor of Science, the Johns Hopkins University with a Master of Liberal Arts, and Loyola University School of Law in New Orleans with a Juris Doctor degree. Please help us welcome our 4 panelists. Javana.
Thank you so much for that, Valerie.
Sure.
I think our first speaker is Sonia. Sonia, please take it over.
Thank you very much for the lovely introductions, and I'm sort of overwhelmed and so delighted at the level of interest in learning about the Maryland procurement law, as shown by all the audience here today. But before I get started with my portion of the discussion, I think Melody needed to put something on the record here.
Thank you, Sonia. Just a minor disclaimer, with working in the Attorney General's office, just wanted to mention that my comments or participation in this presentation are not the opinions or comments of the Attorney General. Thank you so much.
Also, I would like to thank both Melody and Phil for doing the lion's share of putting what you see in front of you, which is the PowerPoint presentation. And I think something like, how many slides? 30 slides. And so I really appreciate the amount of time that you devoted into kind of putting this together while Larry and I were sleeping. So to start off the discussion, I would like to start with kind of providing an overview and sort of a background of what the board is, who we are, and what we do. Next slide, please. The Maryland State Board of Contract Appeals, we are a statutory body that was set up to adjudicate bid protests and contract disputes that arise between state government and contractors that do business with the state. We are an independent unit of the executive branch of Maryland state government. We currently are 6 board members. They're all appointed by the governor. Each of us have staggered 5-year terms. Prior to 2022, I want to say July 2022, there were only 3 members, but there was a new law that got passed that expanded the board to 6 members, and this is how we came to be, how we're constituted currently. All of the hearings that we have, that we hear, are subject to the application of the APA, Administrative Procedures Act, because they're all contested hearings. We sit as 3-member panels, no more than 3 members for each appeal that we hear. To appear before the contract appeals, obviously, well, it's not obvious. You can, as an individual, represent yourself pro se, but as you might imagine, most of the contractors that appear before the board are companies, and companies are required to be represented by counsel, which is where all of you come in, right? As representatives of counsel, of companies, as well as on behalf of the state agencies. Next slide, please. And Larry later on is going to talk more specifically about the kind of the bid protests that we handle, and I think Melody is going to discuss the contract case. Yes,
I believe that
or Bill.
and then I'll wrap up.
Everybody's lucky Melody will do it instead of me, but I think I'll start. Contract.
So the way the board came to be is this: in 1976, the state enacted the waiver of sovereign immunity that is now codified in State Government 12-201. And what that statute requires is, has carved out, is a very, very small sliver of waiver of the state sovereign immunity for certain cases. And so if you look at the slide, it has 3 major requirements, which is that the contract needs to be in writing. The contract must be entered into by a state personnel with express authority to enter into the contract on behalf of the state. And then all of the approvals need to be met before all of the other state required approval need to be met before that contract can be sued upon for the waiver of sovereign immunity to apply. And you notice there no recovery under quasi contract. So because we are a statutory body and our jurisdiction is based solely on what is specified in the statute, we have no jurisdiction as a board to consider any claims that are sort of quasi equitable claims in nature.
I'm sorry, Sonia, sorry to interrupt you, but there seems to be an issue with people not being able to see the PowerPoint. Can everyone see the PowerPoint presentation? Okay.
Yes.
Okay, perfect. Sorry about that. Thank you.
So what this means, I mean, this is probably the most important thing to understand about litigating before or bring any claims before the Board of Contract Appeals is that very specific requirements need to be met before we can exercise jurisdiction over any claims of or protests that have been rejected by the agencies. So for instance, there have been litigation in the past involving subcontractors bringing lawsuits or trying to bring lawsuits against the state agency, claiming that there is some sort of a quasi contract entered into between the agency and the subcontractor, unless you have a specific written agreement that is signed by the procurement officer or a person that has explicit authority to enter into that contract, there is no standing to sue, at least not before the Board of Contract Appeals for a procurement contract. Next slide, please. Okay, and the board's jurisdiction derived from the general procurement law, which is specifically laid out in Division 2 of the State Finance and Procurement article. And the Division 2 basically runs from sections 11 through 19 of that code. And if you go to section 11-202, that is a section that lists all of the scope of all of the cases that over which the board has jurisdiction. But then if you go to 11-203, there is an even more exhaustive list of all of the claims or the type of cases that are excluded from the board's jurisdiction. And council would be very wise to become very, very familiar with what falls under the board's jurisdiction versus not, you know, in litigating before the board. Because you will run into standing issues and jurisdiction issues. Oh, and of course, you need to be very familiar with the COMAR section. In Title 21 of COMAR specifically lays out all of the regulations that apply in sort of the procedure that applies to litigating procurement contract disputes before the board. So you should be very familiar with that too. Next slide, please. Oh, okay, I already kind of talked about it ahead of time, sorry. I think I talked about all of these things on the slide already. I'm sorry, I got a little ahead of myself. And obviously, I mean, I did talk a little bit about section 11-202, the scope of our jurisdiction and the exclusions in 203. But one of the things that I think is important to remember is the kind of the purpose of the general procurement law that's listed in section 11-201, which it's not specifically listed on this PowerPoint presentation, but that has maybe 10 or 11 things that it lists as the primary purpose of having enacted this general procurement law, which includes, you know, fairness to contractors, but also maximizing the state's purchasing power, right, in being able to command goods and services from the best possible services that are out there so that the state can maximize the value of, what's the word I'm looking for? Maximize the value of the tax dollars that are being spent in procuring all of these goods and services on behalf of the state and the many agencies that it affects. So I think that's pretty much all I have to say about that for you, unless there are any questions about anything I said. Thank you.
Thank you, Sonia. As I was introduced earlier, I'm Larry Kreis, and I'm going to be talking about protests today. Due to the time constraints we have, I have 10 to 15 minutes to tell you everything you need to know about protests, which can be pretty difficult. So I'm going to try and keep it at sort of a higher level. Protests, both initially in front of the state agency and then ultimately in front of us, are administrative proceedings. The process is not as formal as if you were in a circuit or federal district court. But I guess the cautionary tale is there are some very strict statutes and regulations that apply to procurement proceedings. And it's an area of law that is open to have more people practicing in the area, but it's also an area of law that you have to be very careful about sort of dabbling in, because you can find your client and yourself behind the eight ball pretty quickly in dealing with issues if you aren't aware of exactly what the procedures are. As you'll see going through these slides, most of them have cites to COMAR. COMAR is your friend, and state finance and procurement is your friend when dealing with any issues dealing with procurement, whether it be protests or contract claims. But specifically, protests, it's a document that is filed in writing, has to be addressed to the procurement officer. Procurement officer is the representative on behalf of the state who is in charge of basically running the solicitation and then monitoring the contract once an award is made. Protests are filed by an interested party. It's another buzzword I'll talk about a little bit later on this slide. And they can be filed by mail, hand delivery, courier, and now by electronic means. So what is an interested party? An interested party is a prospective bidder or offeror or contractor who's either aggrieved by the solicitation, the proposed award on the solicitation, or a protest that's filed in the solicitation. So generally, when dealing with protests, they fall into two types of categories. There's a lot of types of protests within the categories, but there's what's known as pre-proposal or pre-bid protests. And I do say both because a bid is different from a proposal. We don't have the time really to go into those distinctions today. So I'm just saying generally pre-bid protests. Basically, if a contractor or offeror is aggrieved by the terms of the solicitation when it comes out, and it's apparent in the solicitation when you get it, you must file your pre-proposal protest before the deadline for submitting your bids or your proposals. You can't wait to see whether or not you get the contract and then say, hey, this provision was really ambiguous, and that's why I didn't get it. It's too late if you don't file your protest before you submit if the issue is apparent. Another cautionary tale at this point would be that if you file your bid pre-submit or file your protest pre-submission, and the time to submit bids or proposals comes before you get a final resolution, you should submit your bid or your proposal pending the resolution of your protest. The second category of protests are what I call intended award protests. So now the state agency says, you know, you didn't get it and someone else has been selected for award. And you don't think that's right. You think either they judged you wrong, they judged them wrong, whatever it is, you think there's a reason why it shouldn't have happened the way it did. You must file your protest within 7 days of when you knew or should have known the basis for your protest. And this is one of those things where time is very strictly construed. It's 7 days, knew or should have known. We have a plethora of cases that were thrown out for being a day late, an hour late, a week late. There's a lot of litigation as to what should have known is in our case, over history too. When a protest is filed, one of these post-award protests, the intended awardee can enter the protest as an interested party to try and protect its rights that the contract that it's hoping to still receive. You can go to the next slide, please. So what do you have to have in a protest? So a protest needs to contain the name and address of the protester. It needs to include the identity of the procurement or the contract in which it's being filed. It needs to contain the reason for the protest. And it needs to contain supporting documents that are available at that time. Now, reason for the protest is a little tricky because you only have 7 days from when you knew or should have known to file it, but you can't file a placeholder protest. There has to be an actual reason. You can't just say it should have been awarded to me. Because things are discovered throughout the process, you see, I know Mr. Andrews has done that once or twice, but
Let's not pick on Mr. Andrews.
but so what often happens is a protest is filed, and then some people call it a supplemental protest is filed, or a second protest is filed when more information is gained, and you can have multiple protests within the same contract. Hopefully they all catch up to each other and can get consolidated either in front of the agency or ultimately if they're appealed in front of the board. But once this protest is filed, the procurement officer, which we discussed a little bit earlier, must expeditiously as possibly issue a written decision. The written decision, before it can be issued, must be reviewed by the Office of the Attorney General and must be reviewed by the reviewing authority, which for purposes of today is someone higher up the chain than where the procurement officer is at their agency. The decision must describe the controversy, state what the decision is on the protest, and if it's sustained, it's required to also contain very specific language notifying, if you can go to the next slide. It has to have very specific language that says how you appeal the protest and who you appeal it to. And that's where we get to protest appeals, which is the slide that's up there now. And basically it says, you can agree, if you're aggrieved by an agency decision, a protester may file an appeal to the Maryland State Board of Contract Appeals within 10 days of receiving the final decision. And again, the time frame on this is also strictly construed. If it's not timely filed, the board cannot consider the protest. And again, we have a long list of cases where this has been litigated before us, and it still happens because the timeframes are so short. If you can go to the next slide. So the MSBCA jurisdiction, as Sonia had stated earlier, is basically dealing with protests and contract claims. And Mr. Andrews is going to deal with contract claims a little bit later. And I should say timely filed protests and claims is actually what our jurisdiction is. I like to distinguish between protests and claims, but I say that protests are more akin to like state district court and claims are more akin to state circuit court. Now, the only difference is the state district court has a monetary limit of what you can bring there. Protests can be multi-million-dollar contracts, but the way it's similar to district court it's a sort of a faster track proceeding. There's less discovery, decisions come out more quickly, whereas claims follow more of a circuit court procedure with a scheduling order, more discovery available, a longer time frame to getting to the merits hearing, motions hearings, and ultimately the decision. On our website, which is up on this slide, there are a lot of sources that are available that are helpful. We have a searchable database of all the board's reported decisions. And this is really helpful. It's not the best searchable thing, but it's the only searchable version of our reported decisions. Our decisions don't appear on anything like Lexis or Westlaw, so it's a way to see what we've done in the past. Our website also contains form board protective orders that deal with confidentiality, which often arises in protests. We have form subpoena, and we actually have some board guidelines for litigating protest appeals and contract claims. Board guidelines can change from time to time. So again, they're not the regulations or the statute, they're guidelines. When dealing with protests and claims, the COMAR section 2110.05.01 through 0.15 generally tell you how to litigate or how to pursue matters in front of the board. And then the last thing on this slide is state finance and procurement sections 15.221.1 and 15.221.2, which both just became effective on October 1st of 2024, authorize the board to award reasonable attorney's fees and costs in filing and pursuing a protest or contract claim. There's a lot more to this than we're able to discuss today. And like I said, it just has become effective in October. And there are COMAR regulations that have been approved to implement it or have been submitted to implement it and are waiting approval for, how to go about, implementing the statute. If we can go to the next slide. So in protests, once the protest is filed, appearances are entered, the first real substantive document is required by the state is required to file. It's the state's agency report. It's a report that basically reports on all the actions taken by the agency regarding the solicitation and evaluation and selection decisions made by the state agency. If you go to the COMAR section on this slide, it also lists numerous things that need to be attached to the agency report. So in addition to being sort of the state's position on where things are, some documents are turned over. It's almost like a preliminary discovery. And once the state issues its agency report, the protester or the interested party may, but is not required to file comments in response to the agency report. If either or both file comments, the state agency may file a rebuttal. So we can go to the next slide, please. So in protest appeals, as I said, I'd say they're more akin to like district court. The only discovery in a protest appeal is usually limited to requests for production of documents. If there are extraordinary circumstances, the board may allow limited additional discovery if it finds it's justified to avoid substantial unfairness or prejudice. It could allow for some interrogatories or for a deposition. But what I would say is it is extremely unusual to have discovery beyond a request for production of documents. Like I said, that is the ordinary in protest appeals. Anything else would be extraordinary. And it has happened in my years of practice. I could probably count on one hand how many times it's happened. And there's a reason for it too. Protests, there's a balancing act with protests. And the balancing act that the trying to achieve by this process is that the state obviously needs to issue contracts and needs to move forward on contracts in order to keep sort of the wheels turning and the state running. But at the same time, people who are going to bid or go through this process to try and obtain a contract have to have procedural safeguards, substantive and procedural due process rights. And so it's a balancing act of trying to give people the opportunity to challenge alleged errors in a procurement or a recommended award while still allowing the state to move forward and conduct business as usual. If we can go to the next slide. So when you have a protest, there's a possibility to have motions. There's a general motion section in COMAR that allows for the filing of motions. The two that we see most often are motions for summary decision and motions to dismiss. A motion for summary decision is basically the same standard as a motion for summary judgment in state court. If a motion is filed and if a hearing is requested, the board generally will hold a hearing. However, it is discretionary and the board may rule on a motion without granting a hearing if it doesn't believe there's a need for one or time for one, and it has ruled without hearings before. If no motions are filed and or a motion is filed and it does not dispose of the entire matter, ultimately a merits hearing is conducted. A merits hearing is much like any other hearing you would have. There are opening and closing statements. Witnesses are called. evidence is entered. The strict rules, Maryland rules of evidence do not apply to us. We're an administrative agency. Hearsay is admissible at our discretion. And ultimately, the standard at the end of the day is whether or not the procurement officer was biased or their decision was arbitrary, capricious, unreasonable, or illegal or unlawful. And it's basically the administrative standard of review, which is a very high standard. The other thing to understand is even if you win or the appeal is sustained, all we're determining is the fact that the decision of the procurement officer was not appropriate. We cannot direct the state to award it to your client who just won the protest. We don't have any control to take affirmative action. Once we make our decision, it goes back to the state to decide how it wishes to proceed, whether it wants to try and move forward in the face of the protest, whether it wants to make some kind of amendment to the solicitation, whether it wants to cancel it and start over. There are many options that can take place. All we control is whether or not the process was complied with up to the point we hear the case. At the end of a case, we generally issue written decisions. Occasionally, we will rule from the bench with a decision to follow. And that's about all I can tell you in the time that I have allotted for protest today. So I'm going to pass it on to Phil to talk about contract claims now.
Go to the next slide, please. What our two board member panelists have said about time constraints and time limits and strict deadlines and getting the jurisdiction of the Board of Appeals to attach, I can't stress enough how important it is to pay attention to 7-day rules, 10-day rules, 30-day rules that you'll see as you look through COMAR, whether you're dealing with a protest or a contract claim. But let's talk about contract claims now. Every state contract will have a disputes or dispute clause in it, whether it's the long form or the short form. And what all that means is that you must exhaust your administrative remedies and do so properly and timely before you can have your case heard by the Board of Contract Appeals. So the exhaustion of state remedies in this circumstance occurs at the agency level. You're the contractor, a dispute arises, and at that point, you have to start making a number of strategic decisions, because to get a contract claim properly moving forward, you need to file a notice of contract claim. Your notice of contract claim has to be filed within 30 days of the day when you knew or should have known of the basis for your contract claim. As a practical matter, it's often very difficult for contractors who don't want to fight with the state agency they work for, number one. And number two, the knew or should have known, all of us lawyers know that can be a somewhat tricky concept to sort out or to litigate. But the point is, you file a notice of contract claim. And I should say, before we move on to the next slide, that contract claims may be filed electronically, but only if expressly permitted. And that means, does the contract itself or does the RFP or any of the other procurement documents that make up the contract, does that allow for electronic filing? There is more of that now than there was 5 or 10 years ago, but understand that that's you need to check to be sure that you're allowed to file electronically as opposed to hand delivering it. Next slide, please. We've already heard about the general procurement law, and general procurement law contract claims go up through the Board of Contract Appeals. If you are not a general procurement law or Division II state contract, and again, university contracts are something separate. If you're some other kind of state contract that is not being administered through the general procurement law, then you go to circuit court. As the slide points out here, University System of Maryland, Morgan State, St. Mary's College, each of those will have its own procurement policies and procedures. And if you have a contract, your client has a contract with one of those institutions, you need to look carefully at those particular institutions' policies or procedures. Once the claim is filed and you've got a final decision on your claim, then everybody goes to COMAR and COMAR will govern what happens to claims after that. And I know that Board Member Christ said that COMAR is your friend. Sometimes it's your friend, sometimes it's not your friend, but you need to pay attention to that potential friend. Next slide, please. All right, so let's go back. I mentioned a moment ago a notice of contract claim. So there are two parts to this. You don't have to file a notice of contract claim and wait a number of days and then file your actual contract claim. But you have to file a notice of contract claim within 30 days after the basis for the claim is known or should have been known. All right. The Maryland's procurement law, for reasons that are not entirely clear to some of us, makes distinctions between construction contracts and non-construction contracts, and a non-construction contract will be for services, some other goods. So if you, every contract has the notice of contract claim within 30 days requirement. If you have a construction contract, then your contract claim is due within 90 days after your notice of contract claim has been filed. All other contracts is within 30 days. If you are at the end of the contract and you're getting close to the date final payment is made, keep that in mind as another potential deadline as well. You can file your notice of contract claim and the contract claim itself on the same day. That's fine. You don't have to wait 90 days or 30 days after the notice of contract claim. But again, if you take nothing else away from what I say today, please pay attention to these deadlines. They are, I describe them to clients as guillotine items. And I can also say, with all due respect to my friends, both here and who are in the audience out there, if the state agency has the opportunity to make an argument that your contract claim is untimely, the agency will do so. So what has to be in a contract claim? Well, the notice of contract claim basically is so the state's not surprised by what you're going to claim. It's not to say a lot. If there's an email that says we've decided we're going to assess liquidated damages because of X, Y, or Z, and client doesn't like that, and there's no way around that, it's going to happen. Okay, your notice of contract claim can say we're giving notice of our claim. See the attached email, and we'll file our contract claim within the time required. So what has to be in the contract claim itself? Well, you have to set forth specific information. Again, I would urge you be more detailed rather than less detailed. As the slide says, the amount of the claim, the facts support it. There's also a certificate of good faith, if you will, the good faith basis for the claim. What the person who signs the certificate says is that the supporting data are accurate, complete. Amount claimed is actually what we're owed, and the state should be liable for that. And one more time, if I haven't said it enough ad nauseum, time limitations to file a claim are strictly construed. Next slide, please. Okay, so how long does one have to wait to see what the procurement officer will say about the contract claim? The agency has 180 days to issue a final decision. If you have an expedited claim, the time to issue a final decision is 90 days. If the agency does not issue the final decision within 180 days, then the contractor can see it as a pocket veto, can deem the failure to issue a decision as a deemed denied. And once you are deemed denied, or the procurement officer issues a decision denying your claim, Then you have the final action of the agency, either way, either the pocket veto, if you will, or the procurement officer's decision. Now you've got 30 days to note your appeal to the Board of Contract Appeals. So someone say about that. Let's go to the next slide, please. Oh, I went too far. Go back one, please. Because I want to say a little bit more about this. The full discovery item on here. Full discovery is permitted when litigating claims. So the distinction of district court, circuit court is a good one. When you are litigating a contract claim before the board, you've got the full panoply of all discovery, request for admission, depositions, request production documents, and the like. One thing I would suggest to you is that you take a look at the board's filing guidelines, which were mentioned a moment ago. It's on the board's website. Talks about asking for hearings. Talks about hard copies of exhibits. One thing I will say in terms of the logistics of litigating in front of the board, and I say this not just because two board members are sitting next to me, but you will find the board very easy to deal with in terms of scheduling. If counsel come up with a discovery plan or a way of approaching presentation of evidence, at least in my experience, the board is very willing to work with counsel on that. One of the things the board says in its filing guidelines, and it tends to work very well, I think, the board encourages parties to try to agree on exhibits. And a lot of these documents are a lot of these litigations or contract claims are very document intensive, as you'd expect. And there are a lot of joint exhibits. The board likes those, or requires those to be put in a binder. And I would urge you, as when you litigate these cases, you can make life a lot easier for everybody to the extent you can cooperate in agreeing on exhibits and how the case will be tried. And I think you'll find the board is more than willing to accommodate procedures that counsel can agree on or might suggest would make sense in a particular case. Okay, next slide, please. Optional small claims procedures. So these have been newly revised. If you have an amount in dispute that's $100,000 or less, and you make the election as the appellant, the contractor, within 10 days after the notice of docket, you can go ahead with a small claim appeal. Instead of 3 panel members, 1 board member will be assigned, and there will be an immediate informal telephone conference set up to try to streamline the schedule and move the matter forward within 150 days. And it says decision has no value as precedent. Having said all that, I've never done one of those, but I think Board Member Kreis can say something more intelligent about than I.
Yes, the small claims procedure used to be actually the expedited and accelerated, and there were actually 2 types of proceedings. And now we've sort of combined it into one, where they all follow the same procedure. We have not had a case under the new regulation. It just became effective. But I was the sole member on probably about 4 or so over the last year or so. One went all the way through to the final decision issued. One or 2 of them settled before getting to the decision. And I think one of them ended up, once everyone got on the call, realized it didn't meet the jurisdictional number. And so I had to go through the regular process. What I would say is, like I said, claims can be extremely time consuming and costly. If you fit into this category, it is solely the election of the contractor. If the contractor elects to proceed this way, the state cannot object to it. But once you choose to go this way, only the board can allow you to get out of it if the board agrees. It is a successful way of doing things a little bit cheaper. The quick telephone conference really sort of sets some things out. But what I will tell you is part of that expedited schedule is going to be reducing discovery allowed and things like that to get things done. It seems to have been worked well when people have used it. We hope to see additional use of it going forward under the new regulation.
The primary, I'm just gonna put a footnote here, the primary purpose of the revision to this was to kind of streamline the two different categories that we had that didn't really have any practical differences in the way that they were kind of being followed. Not that we've had too many of these, but the other reason for this revision was to increase the amount of dispute, which previously I believe was $75,000 or $50,000. And given the state of the economy and recent inflation, we just thought that it makes more sense to have the small claims procedures apply to something like $100,000 or less per claim. But it does also have the effect of sort of, capping the recoverable damages, as it were, if you follow this, if you opt for this, the small claims procedure.
I'll turn it over to Melody.
Very much. Excuse me. Next slide. Thank you. So the state can also file a contract, also referred to as an affirmative claim. And the procedures are very similar to the procedures that Bill Andrews just discussed for a contract claim. There is one exception. There is no time limits for the state to file an affirmative claim. Just an example of an affirmative claim that actually is a matter of public record because it was litigated before Maryland State Board of Contract Appeals. One of the universities had a construction project where they believed that the state agency believed that there was a defective installation part of it. So they filed an affirmative claim, and that's a pretty good example of what an affirmative claim is. It's more than likely a monetary claim to recoup funds to potentially redo a portion of the contract. Next slide. So just to go over some of the procedures at the MSBCA, the MSBCA's filing guidelines require online filing. And also all of the opinions and orders are online, and I believe that Chairman Cho spoke about the, and/or Board Member Price spoke about the searchable database of all of the opinions and orders of the MSBCA. Very similar to doing a Westlaw search. Just at the top, there's a search button, which is great to be able to do your research. And then also the appeals are de novo. So it really runs through pretty much what a trial would run through, although the rules of evidence are relaxed. But each party can present witnesses and also present documentary evidence. And instead of being called a trial, they are called merits hearings. But there isn't too much difference than going through a full trial at the circuit court or similar to a district court. And then there is, for the most part, deference that is afforded to the state agencies and procurement officer in decisions that are made. There are quite a lot of cases on the deference or discretionary type decisions that are made. So you can find all of those cases very easily on the board's website as well. And also, one of the things to familiarize yourselves with if practicing before the Maryland State Board of Contract Appeals is the Administrative Procedures Act. And that is found in the state government article starting at section 10. And that is a kind of runs the gamut through the start of an appeal before the Maryland State Board of Contract Appeals, going through a petition for judicial review at the circuit court, And also, if you are going from the circuit court, potentially to the appellate court of Maryland. Next slide, please. So many of the state contracts do need to go to the Maryland Board of Public Works for approval. So typically, what will happen when there is an award or the state has determined the proposal or proposer that would be most advantageous to the state, that vendor is an intended awardee and not an awardee of a contract until the Board of Public Works has actually approved the award. The Board of Public Works or the BPW can also disapprove an award. That can happen. And also what's notable, the BPW is very unique to the state of Maryland. It's created by the Constitution, the state's Constitution. And so it's very interesting to watch some of the meetings. They are online now, so you can watch live as they are moving forward. And so if you have the opportunity to do that, they're typically every other Wednesday. I believe starting at 9:30, but you can also go onto the BPW website and check to see when the next meeting is and see if the agendas are also published, so you can see if there's anything in particular that you're interested in. But that would be something that would be interesting to see, especially if you are not familiar with handling claims for the MSPCA or any information, don't really have knowledge about the BPW. Great to log on one day and watch one of the meetings. So the BPW also does have broad authority, except for capital expenditures that are by the Department of Transportation or the Maryland Transportation Authority in connection with state roads, bridges, or highways. So it's again very unique to Maryland and interesting meetings as well. So next slide, please. Now, one of the things that the Board of Public Works can do is award a contract in the face of a protest. That would be if the BPW finds that the contract should be awarded or executed without delay to protect substantial state interests. So that's something to pay attention to, especially if you are the protester. Next slide, please. Before we get to questions, I did want to mention it, and actually collectively, I think we all wanted to mention that in this legislative session, there are a couple of bills that would amount to procurement reform. There's actually the Procurement Reform Act, I believe that's Senate Bill 426. And another bill of interest would be House Bill 304. So you can go on to the General Assembly's website if you're interested to read through the procurement reform bills. You can do a general search or type in those numbers, and they should come up fairly easily. And I don't know if anybody else would like to comment on the procurement report.
I'm not going to comment on pending legislation. We just implement things once they get passed.
It's fairly early session, so there are significant additions to what we read today.
The one thing I will say is that there, in recent years, particularly this year, been a lot of attention focused on procurement, and there are a lot of challenges, and so it is worth keeping an eye on this legislation as it is on any potential new law that will affect what we all do. But it seems to have front and center attention this year in particular.
All right. Valerie, your turn.
Yep, we do have a question in the chat. I also put something in the chat that if you have any questions, you can enter them in the chat so that we can get to them at the end of the presentation. Josh Mitnick has a question regarding whether or not there are unreported opinions and orders of the MSBCA, or are all of the opinions and orders posted on the website?
So we publish final decisions of the board that are appealable. We're not typically we do not, or recently we have not been publishing discovery orders, for instance, because I find that when they are listed on the, posted on the website, it causes a lot of confusion about kind of the nature of the orders. In other words, are they final decisions that are appealable or not? Discovery orders have no precedential value because they're very fact specific to those particular cases. But obviously, all of these documents and records are available to the public. So, if you're looking for something specific, you may be able to call our clerk's office and find, have those orders sent to you, but we only publish final decisions.
Okay, thank you, Sonia. We had a few questions as well. You answered many of them, but one of the questions was on average, and I guess you can do an annual average. How many protests settle and how many claims settle on average?
I can't give you an annual number, but I will say that most claims settle, whether through, just kind of going through litigation and settle on their own, or we recently had a hearing that went to a merits hearing, and parties decided to settle after 5 days. So that just recently happened. But most claims do settle, I think, because after going through discovery, there was some recognition on both parties that there is risk in some form or another. Bid protests I can't recall a single bid protest that's settled in my tenure here.
Like I said, usually by the time it's gotten to us, it has been decided by the procurement officers. There's a decision that generally has, denied the protest, and the state's trying to move forward with the contract. So it's kind of, there are some that do settle. I can't remember any recently, but it'd be more unusual for a bid protest to settle at that point. Sometimes they settle before they get to us, the administrative level.
I think cases have been withdrawn for a variety of reasons, but I can't recall any specific case that's settled.
I've had one the time I've been doing it. It was a bunch of years ago, and the protester and the interested party they were competitors, but they had some business relationships previously, and I think one principal of protester and one principal of the interested party spoke to each other, worked out something so that the contract work could be split up a little bit, and the state agency agreed to it, and that one settled. But otherwise, if you like to try cases, represent protesters, because they typically will go to a merits hearing.
Right.
And the other reason for potentially these bid protests appeal not settling is the kind of the limited time in which we have to dispose of these cases. So we have a statutory mandate as a board to resolve the bid protests in an expedited manner, which means, practically for practical reasons, we like to sort of get rid of them within 3 to 4 months of filing. And so that may not give the parties enough time to really negotiate any kind of settlement. And, if you think about the subject matter of the bid protest, they're not really, there is no kind of money being exchanged that would satisfy everybody. It's either, a declaration on what happened during the procurement process, which is, did the agency do something that violates law, or was some action arbitrary or capricious? And so there's very little room, other than saying, okay, well, you can award the contract to us. There is very little room for negotiation.
Sure, okay. We have another question. Are MSBCA filings public records, similar to court records? Are they considered public records?
Yes, and if you want to keep things out of the public domain, you need to have them designated confidential.
And then do you see a lot of untimely filed protest appeals or claim appeals that are
Yes.
untimely filed? You do?
All the time.
And so is it the board's preference that when responding to such untimely filed claims or protests, that there's also an argument on the merits and not just it was untimely filed?
Let's see. I don't know that the board has a preference. I don't think we're in a position to tell council kind of how to litigate and, what to do.
Okay.
Each case is so specific, but if you have, certainly if you have defenses that you would like to raise earlier than later, by all means, go ahead and do that. And all we can do is make decisions based on what's filed.
Okay. Alrighty. And I think, oh, okay, one other question. Can you explain the regulatory process for COMAR that govern the MSBCA? And I think we mean, can you explain, when the regulations need to be revised or changed or reviewed that are the board's regulations? How does that work?
You want to talk about that, Larry? We just did some.
Like,
With specifically with respect to the new legislation that governs the award of reasonable attorney's fees in both protest appeals and contract claims. So we went through a kind of a process on that already.
yeah, I mean, basically, depending on whether there's an existing regulation you're modifying or creating a new regulation. If you're modifying one, you bring it out and you sort of do a red line strikeout of it. And then it goes through an administrative process. It gets published. There's comment periods, Maryland Register. And quite frankly, like I said, when it's one we're in charge of, we do the language. And then once it leaves our desk, other people are responsible for the publishing and whatever happens to it. And then ultimately we find out that, it's been either approved or not approved or what its effective date is. And like I said, it can be an amendment of an existing regulation, or it can be new regulations that go with a new statute that's been passed.
Yeah, if you look at the Maryland Register, it's very small print, but there is really a step-by-step piece and talks about all the reviewing authorities and the like. But mostly when it gets that 30-day comment period, if you have a comment, you should submit it and you go from there. But there are a lot of steps to it. It's one thing I remember, and if I have to figure it, I go back and read it. I can't memorize it.
Great. Okay. All right. Thank you. I think those are all the questions that I have. Javana, I'm going to turn it back over to you.
Thank you very much, Valerie. Thank you very much to our panelists for volunteering their time and efforts for today's training. It was an excellent training. A recording of today's training will be available on MSBA's website. There was a question about whether we have permission to share your slides with the people that attended. Are you guys okay with that?
The caveat about representations is in the recording, so.
Okay. All right. Well, thank you so much. Sorry about keeping you for a little bit longer, but have a great evening and thank you for joining us.
Thank you so much. Did a great job. And thank
Thank
you,
you.
participants, for coming and listening. Everyone have a great evening.
Take care, everyone.
All right.